Hey everybody, I'm Damon Moore. If you are involved in a case where a judge is going to be determining where a child should be placed, then this is going to be a good video for you. A lot of judges consider something that they call best interest of the child factors. They're looking at a set of things and trying to determine from those things whether it would be in the best interest of the child that the child be placed with a certain person. And so we're going to look at some factors. Here's what I found in my experience as an attorney. If a child is at an age where a child is breastfeeding, then that is going to be a factor that, at least in my experience, judges take into consideration. You're going to have a hard time making an argument, if you're the father, that the child's best interests are served by the child being with you when the mother is saying, hey, I'm breastfeeding, the child needs to be on a consistent schedule for that to take place. That's a lot harder argument to overcome. On the other hand, when the child is 14, the child may be able to say to the court, hey, this is what I want. And the court may be much more likely to take into account what it is that the child wants to do in that situation. Now, it doesn't mean that the child can declare at 14 that the child wants to live with mom or dad, and that's just the end of it. However, the courts recognize that at that age, the child is much more capable of understanding the consequences of the decision, and the courts tend to believe that the child has a maturity level necessary necessary for the court to take the child's opinion into consideration. Another important factor that the courts may consider is the wishes of the parents. Typically, if you're going to have a custody dispute, one parent is wanting the child to be, let's just say in a traditional type of relationship. Mom is wanting the child to be with mom, dad is wanting the child to be with dad, and so there's some conflict there. It's going to be very difficult for the judge to make a decision where you've got some kind of agreement, because there's not typically going to be an agreement. That's why we've got a contested custody dispute. Another factor that the court takes into consideration is the wishes of the child, with extra consideration being given to the child who's 14 years of age or older. Now, I touched on a little bit of that earlier when talking about the age and sex of the child. It's worth repeating. When the child is 14 or older, the child's wishes are going to be more heavily considered. When the child is under 14, some judges might consider the child's wishes in a matter, but in my experience, when the child is under 14, some judges won't talk to the child at all. Others may talk to the child if there's some testimony about how mature the child is and how the judge should listen to the child. In my experience, there is a tendency among parents to think that their children are more mature and just overall superior to the other children around the child. And so I rarely meet a parent who says, hey, my child's just not that bright compared to his peers or her peers. That just doesn't happen very often. Usually the parent is saying how much more intelligent that parent's child is. So because parents have a tendency to think more of their children than the rest of society does, judges tend to be a little less willing to listen to or less they tend to be less likely to be persuaded that they should be considering the testimony of a child that's under 14. One of the other factors that the courts consider is the interaction or relationship between the child and the child's parents or other siblings or step siblings or any other person with whom the child's going to have a relationship. Now, for that particular factor, in my experience, that's where a lot of the testimony comes into play. I know when I talk to my clients, I'm always asking whether the parent has any other children, because I want to get an understanding of what the relationship is between the child at issue and those other children. Sometimes I'll also ask about extended family. So if I'm representing the mother, I may ask the mother to tell me about her relationship with her parents. I may try to find out whether there are any cousins that live in the area, whether there any other family that is going to be around the child if the child is with mom. I'll also ask the same question about the opposing party. Does the opposing party have relatives that live nearby? What's the opposing party's parents' relationship? And how often does the child at issue spend time with that extended family? I think those are important things. It helps you be able to tell a story about the child that's at issue in the case, and it helps the judge to be able to make informed decisions. So I love to know about that particular factor. One of the other factors that the court considers, at least in Indiana, is the child's adjustment to home, to school, to the community. That's a factor that's important. I think one of the things that I like to do is talk about what the child's life is at home. I like to find out how the child's doing in school. That tends to be a very important factor. If the child's doing well in school, judges tend to want to keep the child in an environment that's producing good results for the child in school. If the child has friends in school and moving might cause a problem, then that's something that you're going to want to raise if that's a factor that you believe needs to be brought to the judge's attention. If the child's been spending time with one parent and that parent is not very active in school, that's something that you want to bring to the judge's attention. If one parent has been going to the parent-teacher conferences, if one parent has built the relationship with the teachers and with others at the school, then that's something that you want to bring to the judge's attention as well. That's going to be a factor that's going to be very important. One of the things that you want to consider when it comes to the grades is whether there is an environment that would be more suitable to helping the child turn those grades around. Judges prefer to see a child thriving, obviously, than to see a child not thriving. And so you want to bring that, you want to explore whatever can be explored in when it comes to the grades. Also on the subject of school, one of the things that I've seen in my experience is that it's not uncommon for one of the parents to do a very good job or a very bad job at getting the child to school on time. If one parent is bringing the child to school late, then that's something you want to bring to the judge's attention. If the child is absent or tardy when the child is with one of the parents, then that's something that you certainly want the judge to know. That's going to play an important role in determining where the child gets placed. I should add that if the child is involved in extracurricular activities, then that's something that you'd want to bring to the judge's attention as well. If the child's involved in extracurricular activities when the child's with you, or if the child is going to be involved in extracurricular activities when the child is living in a certain area, but is going to be prevented from being involved in those activities if the child is moved to another area, then that's something that you want to bring to the judge's attention. That's something that any judge would want to know. Another factor that's involved is the mental and physical health issues of the parties that are involved. If any party has a mental health issue, that's something you're going to want to know. When I'm talking to my clients, I tend to ask my clients whether they have mental health issues. I tend to ask whether the opposing party has mental health issues, and I try to encourage the clients to be very open about those things. One of the things that I find that sometimes clients forget is that the other party is telling the other lawyer all the bad things that they can say about you. So you want to keep that in mind, because these custody disputes can be very competitive. And to the extent that it's necessary to say bad things about the other party, you want to be in a position to do that. And you want to be in a position to rebut any bad things that the other party may say about you. So we always have questions about mental health issues, physical health issues, anything that's kind of in that umbrella, because it is a factor that the courts consider. One of the factors that the courts consider is whether there's evidence of any kind of domestic violence or family violence concerning the parties. And sometimes you can view that domestic violence in what you might consider to be the strictest sense of the word or phrase. Has one party struck the other party? But you can also think of domestic violence or family violence in a much broader context, if necessary, or in a much broader way. Has there been instances where the other person is verbally abusive? Or have there been instances in which you have been verbally abusive? Because if you have, then there's a good chance that you're going to have to answer for that behavior if the other party is talking to an experienced attorney. So that's a factor that the court considers, and it's a factor that I think that you've got to take into account when you're thinking about your own case, what evidence you want to put in and what evidence you think you're going to have to respond to. Another factor that the courts consider is whether the child is being cared for by a de facto guardian or a custodian. If someone other than the parent has been caring for this child, then sometimes the court will take that person's opinion into consideration. That issue happens more than you would think, and so you certainly want to be aware of that. At least in my experience, I want to be aware of it when I'm asking about who the child is spending time around, but that can be a factor. Something that's closely related to that is something I hear when I talk to, more so with dads than with moms, but sometimes dads will tell me that the mother doesn't even have the child. They'll say that the mom is leaving the child with grandma, or the mom is leaving the child with some other person. When that happens, I want to be in a position to demonstrate that to the judge. And so that's something that I'm looking to ask my clients, and that's something that the courts will take into consideration if you have evidence to support the claim that the child is spending time with someone other than the parent. Another factor is a designation in a power of attorney of a child's de facto guardian or custodian, or a child's parent. Now, those are factors that apply in determining the best interest of the child in Indiana. And again, in other states, they may have those factors and they may have other factors. One of the things that I like to keep in mind when it comes to determining the best interest of the child, you can bring anything to the court's attention that you think is a factor that the court should consider. If it's important enough, the court's going to consider it. Just because it doesn't fit into one of those boxes that I just described, that doesn't mean that the court's going to say, no, I'm not going to take that factor into consideration. If it's a factor and it's important, bring it to your lawyer's attention. Your lawyer's going to want to tell the judge. If you found this information to be helpful, then please press the like button and subscribe. You can also check in the description for any additional information. I like to place links and other useful information in my descriptions so that you can continue to educate yourself and learn more about this very important thing that you're going to be taking on. I wish you well. Bye.